Mark Whitehead, who's been president of Houston Trial Lawyers Association, director of PPITAS. Our original thought was to make this sort of a presentation of people who are presidents. And we were planning on Steve Fisher being president, and so we kind of liked the name anyway, and so we kept it. So we do have a real president here, at least in the nice position of being an ex-president. If you ever have a question about the disability, Social Security, this whole area that we tend not to think of much, you can't really recover, you can't really practice. Mark is a person who's shown that not only can you do it, but you do a great job for your client and make a living out of it. On his website, he has 3 or 4 books that you can see on this area. So he really is kind of the president or dean in this area of disability, and Mark Whitehead.
Thank you. My name is Mark Whitehead, and I am a recovering trial lawyer. I've been in practice now almost 21 years, and I think probably the first half of my practice I had a significant car wreck docket, and probably tried, I've forgotten now, 50 or 60 jury cases. And what I realized, 2 things. Number 1, I didn't enjoy it that much, and number 2, it didn't make me that rich because apparently I wasn't that good at it. So over the last 10 years, I have shifted my practice over to what I refer to as a disability practice. Now, some people still call me a Social Security lawyer, and I try to dissuade that notion because disability comes in many forms, not just Social Security disability, although that's the one that most people are familiar with. So finally, as of I think a couple of years ago, I have totally abandoned the practice of personal injury trial law, and I now turn all that over to my partner in crime, Shane Cadlick, in my office, and I let him be a slave to a trial calendar, and I'm happy plugging away handling my disability claims. All right. The hero of our story is Mike. Mike is a mechanic, and with all apologies to the lead guitarist for Genesis, I had to change the name of this presentation. Originally, his name was Joe, and Joe was a plumber. But I realized that has some political implications, and we had to change the story up a little bit. So let me tell you a little bit about Mike. Mike's a 56-year-old grandfather. He served in the Army as a truck driver from 1973 to 1975. He served in Vietnam, but he was never in combat. Mike was severely injured while in the Army in a truck accident back on base in Fort Hood. He had multiple spinal fractures requiring rods and screws, but ultimately he recovered and was honorably discharged from the Army. Mike went to work for XYZ Corporation as a mechanic, and has worked there ever since up until recently. 3 years ago, Mike re-injured his back in a slip and fall accident in a grocery store. But he shrugged it off, went back to work, but over time, the back continued to get worse and worse. 3 months ago, Mike picked up his granddaughter on a Sunday afternoon and suffered excruciating pain. He went to the doctor. Doctor said, "You've got to have a fusion." He had surgery. He's now out, but his doctor is now limited to not lifting or carrying more than 5 to 10 pounds for the rest of his life. Mike now walks with a cane and can no longer do his job as a mechanic. Now Mike visits his local attorney and says, "What can I do?" Well, his local attorney advises him, "Well, you cannot sue the grocery store on your slip and fall claim. Your statute of limitations has run. And I really don't see how you can pursue a workers' comp claim because of the issue with the back surgery, the slip and fall in the grocery store, and the fact that you really injured your back for the final time lifting your granddaughter on a Sunday afternoon. So you're going to have problems with course and scope." So, is Mike out of luck? What can we do? How is Mike going to pay the bills? Well, I'm going to go through 3 potential avenues that Mike has to make some sort of recovery, receive some sort of benefits regarding his condition. The first one that we look at is the possibility of disability insurance. Now, Mike works for XYZ Corporation, and as a part of his employee benefits plan, I want to keep my own time here so I don't see Bob. As part of his employee benefits plan, by the way, I've given 20 minutes to give a presentation that the last time I gave this took me an hour and a half, so I'm really flying here. Mike may have disability insurance through his group employee benefits plan. Now, the thing to realize here is that this is probably going to be an ERISA preempted plan. Probably 95% of all disability insurance policies out there that we see are ERISA based. Because usually people don't have the forethought to buy their own, which means they're getting them through their employment. Now, the disability insurance that Mike may have would probably come in segments. The first would be what they would call short-term disability, which is usually for the first 6 months, although that can vary. And then after that, usually the way a policy is structured is he may have 24 months of additional long-term disability benefits that he can get if he can't do his own occupation, in this case as a mechanic. And then after that, the policy may very well cover him up through his retirement age 65, or sometimes policies are written through whatever his statutory Social Security retirement age is, 66, 67. But he can only get that if he can show that he's unable to be employed at any occupation. And some policies have a station and life provision which allow that own occupation, or that any occupation definition, which is pretty tough standard, to have a scalable income clause in it, what we call a station and life provision. Now, the second thing that he can look at, which is probably the most common, what most people see, is that he, under the Social Security system, he's paid FICA and taxes for 5 out of the last 10 years, which means he's fully insured through the Social Security system. He can file for Social Security disability. Now, under Social Security disability, if he is disabled and cannot perform any work in the national economy, given his age, education, and past work experience, he could receive benefits for himself based on what he paid into the system based on a formula. And if he had minor children, he could also receive what we call a family max, or ancillary benefits for that minor child. Now, if he receives Social Security disability after a 2-year waiting period, he will also be eligible to enroll in the Medicare program. In other words, he would receive Medicare benefits after a 2-year waiting period. Now, we see some clients who, for whatever reason, don't have enough quarters of coverage. Our fallback position is to have them file for SSI, which is a disability welfare program. This is not optimum and not what we really would like to do. We would really like our clients to be insured through the FICA system because the benefits are better, more money. But as a fallback position, especially if you have people like housewives or people who have been self-employed and improperly pay their self-employment taxes, or on some occasions there are some professions such as school teachers where their companies opted out of the Social Security system. They may not have insured status through the Social Security program. But we're going to assume, and for our purposes here, Mike has certainly paid in FICA taxes for 5 out of the last 10 years. He's fully insured. So we're going to pursue a Social Security disability claim for him. Next, there is a veterans disability program for veterans who are disabled and their disability can be service connected. So as I mentioned in the narrative, Mike was in a truck accident back in when he was in the Army, and they broke his back, but they put him back together, let him go, kicked him out. He worked all this time. But now the argument can be made that this prior back injury back when he was a young, probably I would say he would probably be a sergeant, but he now has military status, and you can make an argument that that injury could be service connected. All right. Now understand that he can apply for all 3 of these simultaneously. Now, they are not mutually exclusive, and if anybody like Joe sorry, I'm back to Joe. And I think Mike walked into our office, that's what we would do. All right, so how do we tell Mike? How does he apply? Okay, well, the easiest way for his long-term disability insurance is you would probably apply through your human resources department at your company, or you could apply directly with the insurance carrier depending on the size of the company, but those are usually in their employee handbook or through what's called their SPD, their summary plan description on how to file the application with the insurance company. With the Social Security Administration, there's 3 ways to do it. Number 1, you can go down to your local field office. Number 2, you could set up a telephone appointment if you're disabled and can't get out of your house and do it over the phone. Or third, you could file the application now online, although there's still a few bugs in that and sometimes you can get stuck in a black hole. I prefer my clients to go down to the office and actually file it, and they get a receipt, and now we have proof of the date that they filed, which is important later on in the process. All right, the definition of disability. We'll start with the disability insurance. Well, first of all, this is a contract. So there is no legal definition of disability. It is strictly what and how the contract defines it. And as I alluded to earlier, typically it is, there is a shifting standard of disability over time. Initially, the standard is you cannot perform the duties of your own occupation. In this case, Mike is a mechanic. That would be considered probably medium to heavy type work. So as long as, obviously, if he's got a 5 to 10 pound restriction, I think Mike could show that he could not perform his own occupation. Now the problem is after 24 months and they reevaluate him. At that point, the standard shifts and becomes an any occupation standard. And the way vocationally this is looked at, there's a government publication called the Dictionary of Occupational Titles, the DOT, not the Department of Transportation, but Dictionary of Occupational Titles. And all work is classified as either heavy, medium, light, or sedentary. Well, per the doctor's definition, 5 to 10 pounds, that puts him somewhere in the sedentary range. We know that his past work as a mechanic is at the medium to heavy range, so based on that chart, we can tell that he's not able to do his own occupation as a mechanic. However, once it shifts, once this standard shifts to an any occupation standard, it becomes much tougher. And what does any occupation mean? Any occupation means you've got to knock out all 4 categories, which means you've got to show he's not even capable of sedentary work on a full-time basis. That's a tough standard. Again, some policies have a station in life provision which says that you have to be able to perform a job that would pay you at least a certain percentage, usually it's 60 to 80% of your former salary. In Mike's position, you know, I'm going to assume that Mike was probably making $25 to $30 an hour at his job. If he's limited to only sedentary work and Mike has no transferable skills, what that means is he's limited to sedentary unskilled work. Well, the argument that I'm going to make in that case is that sedentary unskilled work is minimum wage work, $7.25 an hour. Therefore, even if he was capable of sedentary work, he's still not capable of earning 60% of his former salary based on that limitation. So that would be the argument that we would make for him. The definition of disability for the Social Security system. By the way, we note for Social Security, I think the statistics, the last time I looked at them, that 2/3 of people that applied for Social Security disability are denied on their initial application. It's a high disapproval rate. So that rejected, now that's just something I got off the internet. They don't actually stamp it, but they write you a letter, but it has the same effect. So what are we looking at for Social Security disability? Well, in Social Security disability, there's something called a 5-step sequential evaluation that we look at, which is how the Social Security system defines disability. It's pretty straightforward. Number one, you're not working. By definition, you cannot be working at a full-time basis, and that's defined as $1,000 a month. You cannot be working and be disabled by definition. I have a good friend, and many of you probably know him, who's an attorney who is a quadriplegic, cannot move from the neck down. Yet by definition, he is not disabled because he's working. That's step one, not working. Step two, you must have a severe impairment either physical or mental, and it must last at least, or expected to last at least 12 months. There is no short-term disability within the Social Security system. You must be expected to be out at least 12 months. And I frequently have people that call me up, people who are in a coma for 6 months. You're still not qualified because, assuming you came out of the coma and within a month or so went back to work, you didn't meet the 12-month mark. Again, Social Security disability, there's no short term. At step 3 of the evaluation, they look to see if you meet a medical listing. I can tell you that most people do not. Then at step 4 and 5, this is where it sort of is equivalent to the long-term policy that I just described. At step 4, we have to show they can't do their past work. But it's not just the job they were doing at the time of disability. It's the job, any job they performed in the last 15 years. So we will see people like Mike, who were, in his case, he was a mechanic all of his life. But let's say that for 6 months during that period of time, Mike had a job as a receptionist, which is a sedentary position. Now we've got a problem because Mike has to prove he cannot do the easiest job he did in the last 15 years, not what he did the most of, but any job that he held long enough to learn how to do it. So 6 months would count. At step 5, you cannot perform any other work given your age, your education, and your past work experience. Now, this is equivalent to the long-term disability policy at the what I call the post-24-month period, the any occupation period. It's equivalent to the any occupation definition, with this exception. The Social Security Administration cuts you some slack as you get older, whereas your long-term disability policy will not. So as you move through time, the standard of disability is tougher under a long-term disability insurance policy, whereas you move over time for the Social Security system, the standard of disability gets easier because they assume, rightly so I believe, that as you get older, it becomes harder to place you into a different occupation. The magic number is 50. If you will remember, Mike is 56 years old. It gets easier once you hit the age of 50. That's where some certain presumptions called the grid rules kick in. Gets even easier when you hit 55, and it gets even easier than that when you hit 60. Those are the 3 benchmarks that we look at. So if we looked at somebody under the same set of circumstances, if Mike was 46 instead of 56, we would have to show he's unemployable at any level, even at the sedentary level. But because he's now 56, all we have to do is limit him to no better than sedentary, and we can still win his case because they cut him slack because of his age. The definition of disability for a veteran's disability claim. You may not be able to see it, but that says VA disability in that picture. That was the only picture I could find. Under the veteran's disability system, you have to have a current disabling condition. You must have service connection. In other words, you must show a medical nexus between the condition that you have now, the limitation you have now, and some event that occurred during service. It does not have to be combat related. Remember, Mike's accident was back at Fort Hood, not combat related. Does not have to be. If you can establish that service connection, you will then be given a disability rating. That rating can be anywhere from 0 to 100%. Even a 0 rating has some value. It doesn't have any monetary value, but it has benefit value. It can get you certain benefits that you wouldn't otherwise get. But obviously, we want to get a percentage rating because if you get a percentage rating, you get paid on a scale. Now, the difference in the veteran's disability system is that you don't have to be totally disabled, and you can still be working. You can still be working and get a percentage disability through the VA. My uncle was 60% disabled as a World War II veteran, still working, got his check every month. Yeah. Now, there is another, there's VA pension, which is a separate disability program. It's sort of akin to SSI. It's a disability welfare program. It's very difficult to establish. You must have wartime service, although technically the United States has been in a state of war since 1992, Persian Gulf War I. That status has never changed, so I think you can make the argument that anybody that's served since 1992 has wartime service. I'm not sure how that's worked out in the case law, but that would be my theory. I'm sticking to it. Wartime service, you must be indigent and you must be totally disabled. There's no partial disability under a VA pension program. All right. Let's see, I'm going to skip through some of this. other income offsets. The VA benefits and Social Security benefits do not offset each other. You can get both at the same time. However, disability insurance policies will offset other income because they get to write the policy, so of course they're going to offset it. So the example in my math, and I'm sad to say we're going to have to do just a little bit of math here. An LTD policy will pay 60% of the former salary. We're going to say that Mike was very good at what he did. He made $80,000. That's 60% of that is $4,000 a month. SSDI would pay him $1,800 a month. He may have an auxiliary benefit, a child. He may have VA. Doing all that math, he may, the LTD carrier only has to pay him the difference. They get to take a credit for all these other programs that he's being paid for. Now, under the second hypothetical here, which I'll go through real quick, if you look at and do the math on that one, if he only made $50,000, it would be a total offset, and the insurance company would have to pay zero. However, that would be an illusory contract, and that is not allowed in the law. So all contracts have to pay something, even if there's a total offset. And usually the way these LTD policies are written is they'll have to pay some minimum amount. Sometimes it's $50, $100 a month. Sometimes it's 10% of the monthly benefit. Oops, too much. It has to pay something. All three systems require that you go through an administrative appeal before you have a right to proceed any further. The point is you have to give the VA, the LTD carrier, the Social Security Administration, you have to go through an administrative process, and you have to give them the chance to do the right thing. The administrative appeal is important because it's the only opportunity your client is going to have to put in evidence into their file. Because if you do not win at the administrative appeal level, your next step is federal court review. But this is not like anything that you've seen. You don't get a jury trial. You don't get to introduce new evidence. The only evidence that the federal court can consider under any of the scenarios, we're assuming ERISA cases here. It's different if you have a non-ERISA LTD case. That's a general bad faith claim. But assuming it's an ERISA case, the only evidence that the federal court can consider is what was submitted during the administrative appeal. And this is a trap for both claimants who just think they can do their own appeal. I have people all the time call me, want to do their own appeal. I tell them it's a bad idea. They do it anyway. I have attorneys that don't know any better handle their clients' administrative appeals, and they send a one-page letter. They don't develop any vocational evidence. They don't develop any medical opinion evidence. They don't do a wage survey. All of these things, that's, in my opinion, malpractice. It's a trap. Don't let it happen. Because in the federal court, these cases do not go to trial. They are decided on cross motions for summary judgment, generally speaking. There are some exceptions to that. So you've got to fire all your guns during the administrative appeal, or you might as well stick them in your back pocket because you don't have them anymore. The burden of proof in federal court. It is not stacked in your favor. In an ERISA appeal, most often what you're going to see, the standard of review is an abuse of discretion standard, not a de novo preponderance of the evidence standard. You don't get a de novo review. You get an abuse of discretion standard. The way I explain it to my clients, you can have 3 doctors that say you're disabled. As long as they've got one doctor that says you're not disabled and that doctor is credible, you can lose. So it's not the greater weight of the evidence. You don't start off even. That applies also to the Social Security claim. Let me get it over here. Under Social Security claim, you have to show that the Social Security Administration decision is not supported by substantial evidence, and they are given deference. Under the Veterans Disability System, you have to show that the VA's ultimate final decision was arbitrary and capricious and an abuse of discretion. So again, you are behind the 8 ball, which is why the administrative appeal is so important. It must be done right, and you must fire all your guns, because you're going to have a tough row in federal court. Attorney's fees. you can handle a disability appeal, an insurance claim on a straight contingency fee, just like anything you've ever done in your life. Now, one of the things to consider is that what you're trying to do in the administrative appeal is you're trying to get them back on plan, which means you're trying to get their monthly benefits again. So you may have to consider whether or not how you're going to charge them, whether your contingency fee is going to apply just to their back benefits or whether it's going to apply to their future benefits as well. If it is going to apply to future benefits, how long is it going to apply? How are you going to collect that? These create some complications on applying a straight contingency fee. Now, I'll tell you that if you get to federal court on these cases, generally what happens is you end up negotiating a buyout of the claim if you were successful. And then it's easier to apply a contingency fee to a lump sum buyout. For a Social Security disability claim, your fees are regulated by the government. Currently, the fee structure is you are awarded 25% of their back due benefits, currently capped at $6,000. When I first started 20 years ago, the cap was $4,000, so it hasn't moved much. There are ways you can bust that cap if you get into federal court, but you don't want to really be in federal court on a Social Security case. That's not a good place to be. Finally, on the VA system, up until 2007, it was against the law for an attorney to charge a veteran more than $10 to represent them before the VA. So effectively, attorneys were shut out of the VA disability process, at least at the administrative level, which is where you've got to be, because that's where you've got to prove your case. In 2007, recognizing the situation that the country was in and the number of veterans we had coming home, they changed that rule and allowed an attorney to charge a veteran a reasonable contingency fee to represent them before claims before the VA. Now, what they've defined as reasonable is this: a third of any back benefits is defined as reasonable. However, they don't, just to screw us, they will not withhold that fee and pay you directly if you want to take a third. They will give it all to your client, and you have to trust the client to pay you directly. That's a lot of trust. I will tell you that the Social Security Administration withholds the fee and pays you directly. But they used to not do it on SSI claims. So attorneys used to not take SSI claims because we'd have to get it from the client, and invariably, young lawyers like me who did take them, we got stiffed about half the time. It was about 50-50 chance that your client was going to pay you. So back to the VA system, you can charge your client up to a third of back benefits to represent them before the VA, but you have to trust the client to give it to you. However, if you want the VA to pay you directly, which they will do that, but you must agree to take only a 20% contingency fee on back benefits. Now, I don't know what the rationale behind that is, other than they just don't want us in the system. For decades, for hundreds of years, you do not have attorneys in the VA system, and all of a sudden in 2007, that got dumped on them. They were not happy about it, they fought it. But Congress allowed them to make the rules, and this is the rule that they came up with, and in my opinion, it's strictly punitive. I will tell you, in our practice, we take the 20%, because I've been burned enough on the SSI cases that I love my clients, trust but verify. I'm willing to take the 20%. I think that was my last slide. I am out of time. My website is www.disabilitydenials.com. I have 3 ebooks that could be free downloads that could be useful to you if you want to look at them or to give to your clients. The first one is Disability Insurance Policies, How to Unravel the Mystery and Prove Your Claim. The second one, the Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. I came up with that title. I thought it was pretty cool. And the final one, Veterans Disability Claim, Strategies for a Winning Campaign. Plus, we have a lot of instructional videos on our website. So if you want to download those, they're free. You don't even have to give your information. We don't do one of these hook things where you've got to give your email address or anything like that. If you want to talk to me about a claim, I'll be happy to talk to you about it. I'll mentor a lot of young attorneys. I will tell you in particular, veterans disability claims, there's a big need for attorneys. We only take about 10 cases a month by design because of the structure of our office. we turn down a lot of good cases. So if you're looking for an area to get into, there is room right there, and you can now get paid for it. So if anybody wants to talk to me, I'll be happy to answer any questions later on. Thank you.
If you want to see a really efficient and great marketing website, Mark Whitehead's website and the way it's presented is a real model. Not only is there great information on it, but it's a great website. And so, Mark, thank you. And also thank you for your service to HTLA and TTLA.